My name is Molly Arons. I'm the chair of Smith Amundsen's Data Privacy and Security Practice Group. I'm also a partner in the firm's Class Action Practice Group. I'm joined this morning by Carlos Arevalo, who is a partner on the Labor and Employment team here at Smith Amundsen. Carlos regularly advises companies on employment concerns, compliance with statutes such as the Biometric Information Privacy Act, which we're talking about today, and other federal and state statutes. Carlos and I have partnered on these types of concerns and issues, advising clients as to how Bipa could affect their company. And so we've had a lot of crossover given our practice. Frankly, we're both very interested in how this law has developed over time as well. So we sort of have that inherent interest in following this. This morning, as I mentioned, we're talking about BIPA, the Biometric Information Privacy Act. We could talk about this law and how it's affected companies, large and small, for multiple hours. So this morning, we're going to be focusing on the litigation over BIPA that has been happening over the last couple of months since this law came into effect in 2008. In fact, the use of biometrics in the business world has become widespread, and the types of usage are constantly evolving. For example, employers we're seeing will, be using biometric time clocks to allow their employees to punch in and punch out of work. That's typically how we're seeing it be used. These clocks were typically put in place because employers wanted to avoid other potential legal hurdles of not accurately recording an employee's time, et cetera. So, we're seeing these biometric data identifiers, these clocks, and other ways in which biometric data is being collected that was meant to really focus on some compliance with the law, but companies are getting hit with other concerns and other lawsuits really related on the use of this biometric information. So I'll hand it over to Carlos. He's going to go through the objectives for this morning's presentation.
Thank you, Molly. So today we're going to review the background of the Illinois Biometric Information Privacy Act and its enactment. We'll also be looking at the requirements found in the statute with respect to the information that's being collected, stored, dissemination of it, et cetera, and also the specific kinds of requirements having to do with employees and those whose biometric information is being collected, stored, et cetera. We'll also look at some of the recent decisions, and that's when I say recent, I'm talking about the last couple of months. So these are fairly recent, and there are a lot more that have come down, but we'll focus on the most recent ones. And then we'll go through a little bit of what may be a collection and retention set of pitfalls that we might encounter and the kinds of things that we should be looking at and examining, and finally we'll have a few recommendations with respect to best practices as to how you can avoid some of these pitfalls that we're talking about as you move forward, as you continue to use the information that you're collecting. So let's go over to Molly. She will discuss some of the background.
Great, thank you. So, it used to be that we would be concerned about personally identifiable information, right? People's social security numbers, tax identification numbers, dates of birth, and that sort of thing. What's behind this law? So now we're looking at, it's targeted at this super sensitive sort of information, information that's much more sensitive than your social security number or your tax ID number. As we have here on the slide, this is information about an individual that's biologically unique and in something that you can't change. You certainly can't change your retina or your fingerprint. So fingerprints, voice prints, vein patterns in a person's palm are just three examples of the kinds of biometrics about individuals that are sort of targeted with this law. The overall sort of arc of this law is aimed at increasing security and, to a lesser degree, convenience. Looking at that sort of intersect between convenience and the sort of heightened security that consumers and employees expect about this sort of super sensitive data. So that was the sort of background of it historically. Why did it come into place in 2008, which we'll see in the next slide? It's just like concern over companies collecting the information and what are they doing with it. So Bipa became law back on October 3rd, 2008. We have the sort of citation there for you folks who want to pull up the law to review it. The reality is it's a very short law. You know, there's sort of been discussions about the fact that you could almost fit the entirety of the actual text of Bipa on a cocktail napkin. But what you'll see in the coming slides, of course, is that certainly even given the brevity of the law, there's been much made of it. So within the law, like I said, this was the intent behind it was to regulate the collection, use, safeguarding, handling, storage, retention, and destruction of biometric information. Biometric identifiers can mean everything from a retina or iris scan, a fingerprint, a voice print, or a scan of hands or face geometry. There's exclusions to this, certainly, and one of the ones I like to highlight is that, you know, photographs are expressly excluded from BIPA, but face geometry is included in the definition of biometric identifiers. That's something I want you to keep in mind as we go through these slides, because given the pace at which technology is advancing, you know, companies really need to be cautious of what third-party vendors they're using, the potential computer algorithms that are being used by those vendors, and whether those are really truly photographs or pictures, or whether they could be construed as the facial geometries of employees. As you'll also see, I mean, BIPA is the most stringent of all state laws of this type. It's frankly the reigning biometric law of the land. There's a handful of other states that protect against, you know, collection and require certain disclosures as to collection and maintaining of biometric data. But we really, in Illinois, continue to be at the forefront of the stringency with which this law is not only implemented, but considered by our courts here in Illinois. Again, the purpose of BIPA is really to give individuals control over a private entity's use of their biometric information by requiring notice and prior consent. And we'll go through those requirements here in a moment. Just reading the newspapers, any one of you can understand that a consumer or employee sort of feeling of the right to privacy and their feeling of a right to know about how their information is being collected only continues to go up and up and up. So you have a public that really has a high expectation as to what they think they should know about their private information. Biometric information is top of that list.
So what are the requirements then? Section 15 of the Act states as follows, that no private entity may collect, capture, purchase, receive through trade, or otherwise obtain a person's or customer's biometric identifier or biometric information unless first the individual is informed in writing about the information that is being collected or stored. That must also inform the subject in writing of the specific purpose and the length of term for which the biometric identifier or information is going to be collected and stored and used. And then you must you must obtain a written release executed by the individual. The statute also prohibits the sales, leasing, or trading or profit from that data. And it includes a set of protections and obligations with respect to the retention and guidelines that have to be maintained. And then, as you will see, and as we discuss more the specifics of the statute, you'll note that it creates a private right of action for individuals that are harmed by violations. And that's what's driving some of the litigation that's happening. As you will, again, we'll discuss the cases, we'll discuss what's happened. But the law provides that there's statutory damages up to $1,000 for each negligent violation and up to $5,000 for each intentional or reckless violation, as well as the attorney's fees and costs of litigation, which is what then drives a lot of the class action attorneys to try to get these types of claims moving forward, because they'll have that guarantee that they'll get some attorney's fees out of the deal, and out of the litigation that they initiate. So these, we're looking again at some of the requirements. You'll note then, and Molly is going to discuss, how far-reaching these kinds of claims are, and what the statute has allowed and how it has been interpreted.
Thanks, Carlos. So we have a slide in here about the fact that BIPA really reaches companies outside of Illinois, and we'll go through a couple of well-known companies in the next coming slides as to what that looks like. But we want to caution, companies to think, to avoid thinking that this is an Illinois-only issue. Your physical presence, your sort of venue, and your principal place of your business is not the question. All it requires is that you have some physical presence in Illinois, and that you're collecting, capturing, you could be purchasing, frankly, or storing biometric data of Illinois residents. So you need to consider whether you have Illinois employees, whether you employ individuals that may have, by virtue of their job description, maybe working in Illinois, or have may have their residents move to Illinois over the course of time, because it can be up to as something that Carlos will get into later, a 5-year look back in terms of the biometric data that you're collecting about your employees. So we wanted to caution you to not, sort of focus only on thinking that if you're not based in Illinois, it doesn't apply to you. Much like the California Consumer Privacy Act, which I'm sure a lot of you are considering as well, it can't be as narrowly considered as, just whether you're a company that's based in, in Illinois, much like the CCPA can't be simply whether you're based in California. It's beyond that. So with that, we wanted to go through, this next slide as to sort of the impact of what Carlos was addressing in terms of the requirements or what is provided in the law. So, BIPA really packs a punch. Again, the law applies to anybody that's aggrieved by a violation of the act. They have this private cause of action, and they can recover for each violation. As Carlos pointed out, what's really important about this particular law, and you're not finding it in other laws or statutes, is that the prevailing party can be awarded attorney's fees and expert fees. There's this per violation or each violation award of between $1,000 and $5,000. I want to highlight that yet again because there's also no definitive answer as to whether a violation means it happened with an employee, and you have 100 employees, and they each had to clock in and clock out with their fingerprint. So you just take you would want to say, well, we'll just take each of the 100, and that's how many violations there were. That is not necessarily the case. There are arguments being advanced, and courts are considering whether every single day that person clocks in or clocks out can serve as a separate violation, a separate sort of incident that can add up those numbers to obviously an eye-popping number. Moreover, having done defended class actions brought against companies over time, both employee and consumer class actions, as you can imagine, these numbers start to really escalate very quickly. It's sort of a shooting fish in a barrel type situation for a lot of class counsel that are representing employees or consumers in these types of cases, because they know that there's a high likelihood that if you are not doing what you need to do under BIPA as to one employee, you're likely not doing it with regard to any of your employees. And again, the look back as to sort of the scope of, the years of employment that could be at issue can also have a long tail to it. So there's a lot of incentive for the class action counsel of the world to bring these types of actions. We continue to monitor this as counsel for our clients. What kind of class actions are being filed every week, every day. And I can tell you that these BIPA class actions continue to be filed at a hair-raising pace. Multiple in any given day, certainly multiple during the week, and even the pandemic hasn't slowed down a lot of these filings. So it's definitely a potential money grab for the attorneys that are representing employees and consumers. So, with the next slide, we thought we'd give you, just for purposes of perspective, a pop quiz on what we're seeing, over the arc of this law. So, the question is, in the first 6 years of BIPA, from 2008 to 2014, how many BIPA class actions were filed? And here are our options. A, 115, B, 32, C, 0, or D, 11. So, if you're kind of thinking through this and probably from your own experience, thinking about what this looks like, the answer on the next slide here is 0. So again, this was put into effect in 2008, but yet over 6 years, we weren't seeing any BIPA class actions being filed. What we believe is likely the case is that, it really took time for this to get onto the radar of class counsel that were pursuing other statutory class actions. There's consumer fraud actions that were out there. There's Fair Labor Standard Act class actions or MWIL cases that are out there that were being pursued. And then this sort of bubbled to the top. And then it's become a watershed type statute for class counsel. So our second, pop quiz should really drive this point home. In the first 6 months of 2019, how many BIPA class actions were filed? And here are the potential answers. A, 72, B, 161, C, 15, or D, 225. This is usually a little bit more exciting when we're in a live room, of course, and we're all over webinar. But the answer to this quiz is, let's go back here.
Sorry.
The answer is, no worries. The answer is B, 161. Again, that is just over a 6-month period of time. Numbers are still coming in as to the totality of the number of BIPA class actions that were filed in 2019 and how many have been filed this year. Our expectation would be obviously in 2020, the number of filings is impacted by, the pandemic and the court system not being up and running. But again, I can, just verify from you from watching the sort of daily ticker on this number that the number continues to be very high. And Carlos and I are continuing to field multiple phone calls from clients who are getting hit with BIPA cases left and right. So, we continue to think, and we'll go through why we think that's the case, but just given the case law that's coming down, in the last couple of years, we expect this number to only continue to rise. Carlos?
And so, and my apologies, I couldn't contain the excitement of moving the slides and showing what a huge difference it has took place following 2019. And this is what precipitated. In early 2019, the Illinois Supreme Court issued a decision in Rosenbach and Six Flags. Now, this case involved a 14-year-old who wanted to go to Six Flags. And so, he talked to his mom and they got the information. They paid for it online. He went over to the park and at the checkpoint was asked to provide a fingerprint. I think it might have been a thumbprint, to be scanned. And then he was issued a card. And the card, along with the scan of his thumb, was what would give him access for the season. So he goes home and he talks to his mom, and she's asking for the paperwork, as good moms do. And Alex, the kid's name is Alex, he says, well, it's all fingerprints now. I don't have any paperwork. All right. So, what happens now, right? At that point in time, what becomes clear is that neither Alex, nor his mom were giving any kind of information about that. There was no paperwork. So they didn't get to sign, or be informed of how, this information was going to be kept or stored, or what was the purpose of it. So here you are, within a period of time after that, there's a complaint. And the complaint is really, alleging that the information from Alex's thumbprint is being collected, that there was no information provided to him and to his mother, because he was a minor, regarding the purpose of that collection of that information, and there was never any kind of release provided. Six Flags, files a motion to dismiss, trying to get rid of the case. Their position is that there's no damages because nothing's happened. There's no issue, and the law doesn't, say anything about that. There's no actual harm that has come about. But the court, in its holding, disagrees with that. Okay, and the exact holding specifically says that an individual need not allege some actual injury or adverse effect beyond a violation of his or her right under the Act in order to seek the liquidated damages and injunctive relief. Okay, so actual damage is not required. The Supreme Court found that the violation of Bipa alone, those requirements that we've discussed, providing the information, getting the informed consent and signature of somebody whose information is collected, that just simply violating those requirements is sufficient to state a claim under the Act. And so no actual harm is necessary. Now, what follows, obviously, is all those cases that we're looking at. Molly and I, when Rosenbach first came down, we blogged on the issue and expected that there would be this firestorm of cases and anticipated that things would, get going, and certainly they have. And so it is what's going on. Simply making the allegation that a violation has occurred gets us to, get moving on litigation. And so Rosenbach is really what sets things up to begin the process of escalating litigation on this statute. Molly?
Thanks, Carlos. So yes, as expected, this has really kicked the barn door wide open in terms of litigation. And sort of getting back to that point we were making earlier about, it not being an Illinois-only type law, we wanted to highlight a couple of cases that, likely were on your radar to begin with. So one is a Bipa class action against Google. The background is that Google has, proprietary facial recognition technology that is used in terms of people uploading their photos to their cloud-based Google Photos. The allegations of this particular class action were that, this technology extracts geometric data relating to the unique points and contours of a person's face, and that data is then created and stored as a template. The allegation is that, Google was doing this unbeknownst to the people that were using its technology to store these photos, and that, the requisite sort of disclosure and consent was not provided, and then instead they're really creating these templates in violation of Bipa. The suit was brought by, of course, an Illinois resident and citizen of Illinois, so even though Google is not at home here in Illinois, is based elsewhere, the litigation could proceed. Some highlights about this include the fact that, again, if you're going through sort of the traditional class action assessment that you would do for any case, I mean, there's, common questions here about people, about the facts, and the law that would apply. So there's a host of questions being advanced as to whether or not you can group everybody together. So again, it's that point that I highlighted earlier. Photographs are not included. However, face scans and face geometry is. This is a recent example. We saw, Shutterfly early days. Many people use Shutterfly. That they were also sued under Bipa. And again, many people would say, well, that's ridiculous. These are just photographs. This isn't what was meant by face geometry, but yet these cases, are proceeding, and those sorts of algorithms, the technology being used to scan in and keep these pictures is being considered to fall under Bipa. So, Carlos, the next slide. This case against Google comes on the heels of a case that actually one of our participants, Cody, was just questioning on our Q&A board here. The Google case comes after a Bipa case brought against Facebook. This was a matter that, a lawsuit that had a long life to it, frankly. It was originally filed here in Illinois. It was transferred to California. Facebook likely thought that they would have a better chance of defeating Bipa in their own neck of the woods than here, but that didn't happen. So, the background was that very similar to what we see with the Google case. The plaintiffs had claimed that the Facebook tag feature or suggestion tag feature, whatever you're using, was obtaining face scans of individuals without first acquiring the necessary notice and informed consent. Facebook responded that it wasn't collecting biometric data, that the facial recognition processing didn't do that. They also tried to allege that the Illinois law didn't apply to them as a California company. They tried a host of other arguments, including that there wasn't constitutional standing or Article III standing for the plaintiffs to proceed. It's that same sort of argument that Rosenbach considered, that Carlos was mentioning before the Illinois Supreme Court, that you haven't suffered an injury. It's just a technical violation of the statute and not enough to keep you in court. Those arguments were all rejected. The case made its way up to the Ninth Circuit for review. And then as of January 29th, 2020, essentially on the eve of the case going to trial, Facebook settles the class action for over $500 million. Again, I'm sure not thinking that they were going to be at that position over this this law that, again, could have been probably written on a cocktail napkin. Again, this is just one, the case against Facebook, the case against Google. They're just one of a couple of different cases brought against companies based upon this sort of facial recognition software. We could go through a bunch. Clearview AI, IBM, they've been sued as well. I mentioned the Shutterfly one as well. I know for those of you who joined us because of the challenges for employers, it may seem that we're sort of far afield of that, and we'll get into the particular cases and involving employers in a moment here. But we wanted to highlight this because it shows you the creativity that can be used with Bipa, and the companies that are trying to defend these class action lawsuits are really hitting a ton of roadblocks in trying to find that line to draw for the courts as to what's really within the definition of a biometric identifier and what falls outside the four corners of that sort of definition. So these are just a couple of examples of companies trying to say, these aren't geometric images of people's faces. These are simply photographs or, pictures. It's more static. It's more two-dimensional than what the plaintiffs are trying to advance. And those sorts of arguments are being rejected by the courts. So, if you think about that compared to maybe what you're collecting in terms of biometric data, consider whether, there could be creativity and expansion of what's really seemingly at issue in terms of the biometric data being collected, and that could be expanded fairly easily. So with that, Carlos is going to take you through a couple of lawsuits recently, some defenses raised by employers in the employee class action arena.
So as Molly said, you know, for those of you who are joining us because of, you know, issues with employees, the following cases kind of deal with those particular issues. And these are recent cases. You know, we've opted to kind of focus on things that have happened, cases that have come down within the last couple of months. There are more, of course, but we thought these kind of, you know, signal where things are going. The first case that I'm discussing is that McDonald versus Symphony Brownsville Park. And this is an Illinois Court of Appeals case out of the First District. You know, the plaintiff there is an employee who scanned his fingerprint for a time clock, right? And, you know, she and the members of the proposed class and their collected biometric information is, you know, it's happening, and they are not being informed of the purpose or the length of time that this information will be kept. So, you know, just as we've seen, you know, that kind of begets litigation, and before you know it, there's a claim file. And the allegations that are being made, you know, the plaintiffs are looking for an injunction. They want to stop the company from collecting the information, and they want to force the company to comply with Bipa. You know, and of course, we're looking at those $1,000 damages, you know, the liquidated damages that we discussed, that, you know, even if there's no actual injury, per Rosenbach, those are you know, damages that can be collected. And, you know, to the delight of the plaintiff's counsel and class counsel, the attorney's fees and costs are part of the allegations as well. Now, you know, what happens then is that, you know, this motion, there's a motion to dismiss, you know, but then there's the question that is filed. It's a question as to whether or not, based on the defense that is being raised by the company, is because this involves injury to employees, are we now going to have a Workers' Compensation Act exclusivity issue here? For those of, I'm sure that all the employers in the room know that workers' compensation, that the act, what it allows is for injuries that happen on the job, within the scope of the employment, or during the course of employment, to be provided for. The remedies are very specific, and they're contained to that process. And so then that's the exclusive remedy that individuals have. And so the question is posed to the appellate court as follows. Do the exclusivity provisions of the Workers' Compensation Act bar a claim under Bipa where the claim is that the employer has violated the employee's privacy rights? And the court answers no. Essentially, those claims can proceed. The remedies that are related to work injury that has happened, that's something that can be addressed through the process of workers' compensation, but claims pursuant to Bipa are more of a deterrent type of claims, trying to prevent some injury from happening, and so they are different. Now, what the issue, again, is that there are ways to get out of the exclusivity provisions of the Workers' Compensation Act. And the one that the court focuses on is when an injury is not compensable under the Workers' Compensation Act. And it's exactly what the court says, that because, you know, Bipa is a deterrent, you know, as to violations of privacy, then they are not impacted by the exclusivity. You can escape the exclusivity provisions and proceed with your allegations with respect to Bipa violations. So it doesn't really matter, right? The court finds that the claim for liquidated damages under Bipa don't fall under the purview of the injuries that are covered by workers' compensation. Now that case, the McDonald case, is from September. This is about a month old when that case came down. Now, we have another case that also happens in September, and this one is a case by the name of Williams versus Jackson Park. And now, this case is in federal court in the Northern District. The plaintiff is a nurse at a rehab facility. And she, at this facility, they have handprints for purposes of access, and that's the biometric information that's being collected. Now, the allegations there's no policy regarding the collection, storage, there's no consent form. But in this instance, Williams is a union member. And so as a result of that, and because there is a collective bargaining agreement, the company files a motion indicating or claiming that that the plaintiffs in this instance cannot proceed because they are union members. And so the issue is preempted under the Labor Management Relations Act. Now, the specific section at issue is Section 301, which preempts state law claims if resolution of the claim requires the interpretation of a collective bargaining agreement. What the court ends up saying is that the plaintiffs must resort to the collective bargaining agreement procedures. For those of you that are, union employers, certainly that would require that they file a grievance. Then you have to go through the steps of that grievance, step 1, step 2, whatever. At some point in time, the claim would be moved to an arbitration, right? That process is contained and is pursuant to the terms of the collective bargaining agreement. Once that decision is made by an arbitrator who, handles that grievance, then there's still the opportunity for either side who's not satisfied with the outcome, provided certain, conditions, to seek either to vacate or modify an award that is not favorable. In this instance, in the Williams case, there's no evidence before the court that that process was followed. All right, and so the motion to dismiss is granted, but they're allowed to then bring the allegations. So in some respects, the question is not fully answered yet, but we know that that there's going to be preemption. So for the union employees, for the union employers in the room, certainly that defense is viable. But then it depends. What if other employees within the company or within this employer, they're not part of the union? They can certainly still move forward, and the same preemption argument that's been made with respect to the union employees won't be able, they won't be able to make that argument. So it does kind of limit to some degree what's going on, but certainly it also provides definition for what else is going on here. So it remains to be seen, what the merits are, what the class certification are, what can be advanced. That's still something that's out there that that we'll need to see what happens. Now, this other case that I'm discussing now, that's the White Castle case, and that goes back to August of this year. And there were two issues in that case. That case involved an allegation as to, or the concerns at issue had to do with, what are the acts that violate Bipa under one of the sections, 15B to be specific, and when do the claims accrue? Now, the allegations in that case was, related to the plaintiff in the collection of fingerprint scans to access the system. The plaintiff was a manager, or might be still a manager there, and she needed to access, the pay stub information and other things as a manager. And this practice began in 2007, before Bipa was passed. Now, Bipa then is enacted in 2008, and she didn't receive any kind of release, with respect to, or information about what was being collected, what was being used. And what we have here is something that happens now 10 years later, in October of 2018, she finally does get this release, this information, and is presented with the consent form. So White Castle, moves to dismiss this claims, indicating that, she's lost her opportunity because, obviously the statute was enacted in 2008. The information had been collected, and then she just sat on her claims for 10 years and didn't pursue anything. And so then, what happens is that the parties have arguments with respect as to, this is not necessarily something that can be addressed right away. This is something that continues. This is a violation that has been ongoing, okay? And the court does agree with the plaintiff that the claims are timely. And the plaintiff is argued that this is a continuing violation, okay? That the violation from the moment that the scan happened, it continued and went forward for however long the information has been collected without that informed consent that is required. And certainly that's why this causes of actions, these claims should continue. The court, though, comes back and it says, no, it's not a continuing violation. The continuing violation exception to this sort of situation is not applicable here because BIPA, what it does is that each event, when there's a potential or a scan or a collection of the information, each event constitutes a discrete individual act, not a cumulative act, but each individual act is a violation. So, the ongoing collection, it's not so much the issue, it's the fact that each time that information is scanned or collected, that constitutes a independent violation. And so that's huge, right? It's significant because, we were talking earlier about the fact that, you have an employee at least twice a day may be scanning, when they come into work, when they leave, that's a second scan to, for that time clock to record the information. And then you multiply that by the number of employees, you multiply that by the number of years that we're talking about here. That is huge, huge, huge. Now, what White Castle argues with respect to this particular thing or this particular issue is that this would be so crippling. It would be such a huge problem for them, and that couldn't possibly be what the statute required. But the court, and again, we're talking federal court, so they're interpreting Illinois law, and their position there is that the way that they see the statute is that, again, each instance, each collection is a violation. And even if the consequences of that finding are harsh or unjust or absurd or unwise, that's what the statute provides, and you have to live with it. And the court is not going to make changes. If for some reason the allegations being made by White Castle are true or are accurate, that it is harsh, that it is unjust, that it is absurd, then that's not the role of the court. Certainly, that would be the legislature's job to make amendments to the statute, or, the court does say that if the case progresses and it goes to, goes through the merits of the case, and then there's an appeal to the Seventh Circuit could certainly, request the Supreme Court to clarify this, certify that question for them, and then it would potentially be addressed and taken care of. So, that's how significant we're talking about here. Now, one of the things that Molly mentioned earlier, and this is a case, or I'm going to make a reference to a case that we didn't list in the materials. This is a case that goes back to August, where the question was being asked as to what's the statute of limitation. Molly made reference to this earlier, that is, we're talking about 5 years. BIPA doesn't have a specific statute of limitations provision in it. The laws of Illinois provide that when there's no specific provision, there's a catch-all statute of limitations of 5 years. So there are 5 years that, for things to accrue, and so long as the claims are being made within those 5 years, they're going to be able to move forward. That's the way that was ruled in this Stauffer case down in the Southern District of Illinois, and they relied on a decision from Cook County. So again, the cases are progressing, and we're looking at some further clarification as to what the proper statute of limitations is. So you see how this litigation is kind of developing and moving forward and bringing clarity. It's possible, of course, that more decisions will happen, or that the legislature will take up some of these issues and give it more clarity or definition, and go beyond that napkin degree of the text of the statute, or that the Illinois Supreme Court might take some of those questions moving forward. There are still some additional items that are coming up, particularly with the pandemic, in the impact of what is biometric information, what isn't. And Molly has a couple of comments with respect to temperature, particularly being an issue here.
Thanks, Carlos. So, with so many people having a heightened concern about their workforce coming back on premises and potentially taking temperatures for purposes of, confirming a lack of illness for their employees, one of the things that considered as to, sort of advising clients on this is, you're taking in temperatures, is that biometric information about which you should be concerned? Do you need that same level of consent from your employees that you would get for a fingerprint, for example? So again, biometric information, the answer to that question is no, generally speaking. Biometric information is defined as information based on an individual's biometric identifier used to identify an individual. So we think there'd be like an uphill battle, for a claimant to say that their temperature is that same sort of a unique identifier, the same as it would be with like an iris scan or a fingerprint. And this is especially true since, temperatures can change day to day. So, the conclusion we've come to is really that it's not that same level of biometric information that you would see from other biometric data. It obviously may be a health concern. There may be some HIPAA obligations that you would have depending on what you're collecting and how you're maintaining it, but that this sort of temperature wouldn't fall under that definition of BIPA. And in fact, it could be demographic information or data, which is excluded under BIPA. We have here too that BIPA does exclude, there's an exception for testing and screening information. So just wanted to have a slide in here, maybe on your mind as you're listening to us today, that this sort of registering of information particular to an individual does not qualify. At least what we've seen is biometric data. There would be arguments to be made that this was outside the four corners of what BIPA requires. So with that, we wanted to, before we conclude this, go through some other things to have on your radar in terms of how this law could move forward. So, obviously the court system is not being as friendly to companies and employers as we'd hope or like. So, is there legislation that we could see in our future in terms of, protections for companies, some sort of, limitation on the level of exposure you may have, liability exposure you may have in any given case, and really what are we seeing on the national or federal stage? So, recently there was a statute, the National Biometric Information Act of 2020, was introduced into the U.S. Senate. This was really recent, but certainly something that we're tracking and considering in terms of a broader reach of these sorts of biometric requirements in this law. Again, Illinois is really top of the list in terms of the potentially draconian remedies and impact of a BIPA, of a biometric law. Like there's a handful of other states. The California Consumer Privacy Act obviously has a requirement of disclosure about biometric data. There's potential statutory damages in that act as well, but it's a very distant second to what Illinois has. So what we're tracking is whether there will be a similar federal statute to what we're seeing in Illinois. So that's to be determined, and again, we'll be following that. There's also been efforts, of course, as you can imagine, in Illinois to try to modify the law, to try to amend it so that it's not as wide-reaching, as not as hot of water as you could probably experience as a company. So there's a half a dozen or more different bills that have been introduced, and we wanted to highlight a couple. So one of the House bills that's been introduced would limit, as both Carlos and I have talked about, sort of the amount of time that could be at issue, requiring that an alleged violation of the act be commenced within a year after the cause of action. That's actually thread through a few of the bills that have been introduced or pending. There's also efforts in these same bills to, in this House bill in particular, to limit the amount of damages available, that it wouldn't be the liquidated damages that we've been discussing, but really a limitation to the actual damages. Other bills that have been introduced seek to stamp out this sort of private cause of action. Instead, it would be something where the Department of Labor alone would have the power of enforcement and regulation. That's been thread through as well through a bunch of these different acts. I will say that similar to other federal statutes and state statutes, what really breathes tremendous air and oxygen into the prosecution of companies based upon Bipa is this sort of private cause of action, this idea that you're empowering private citizens and plaintiffs' attorneys as almost private attorney generals to pursue these sorts of violations of the statutes. It's what we've seen at the federal stage, why some of the consumer acts that are out there and are the base of class actions have really just had a watershed moment themselves, is because the statutes and those acts, the provisions of it have been taken out of the hands of a federal agency and put in the hands of private citizens. That's really when we're seeing these acts turn a corner. So what we're seeing with these submissions to the Illinois Assembly and otherwise is this idea that you would completely remove this sort of private cause of action and require a state, public actor, be it the Department of Labor or otherwise, to pursue companies for violations of Bipa. So something to keep in mind, something we're absolutely tracking, and we'll certainly obviously update everybody on if we see some developments in those ways. So with a few minutes left, we wanted to bullet point through a couple of pitfalls, and then we'll get to best practices. So with pitfalls, Carlos, looking at this particular slide, for me, I see, and it's obviously number one here, is, again, this sort of potential misuse or mishandling of biometric data. The fact that you may be taking it in, not making the disclosures you need to make, and then mishandling it. And I will say that, what we see generally, not even just limited to biometric data, but personally identifiable information is, companies are they're casting a wide net and collecting a whole bunch of data that they probably don't need. And then they're maybe keeping it longer than they should keep it because they just don't have a destruction or deletion sort of policy in place that could potentially address that and get rid of it so that you're really narrowing the potential exposure you have. Carlos, what thoughts do you have in terms of what you're seeing in terms of pitfalls for companies?
I would agree with you. It's the same issue. Again, I think we need to look at this as a need to institute safeguards for the information that we collect as employers. So as you mentioned, it's not just the biometric information that we're dealing here, but we also have all this other stuff, and biometric data is we are to protect it just as much. That's what we're looking at. So whatever methods, whatever safeguards we can institute we should be doing that. We should be looking at it. We should be analyzing how well we keep it. The problem being, of course, that if we don't, there comes the mishandling. So we're on the same page with respect to those issues there, and the fact that that the statute is it's still being worked out, and so then there's areas that we don't know whether we might have an issue later, that might become litigated, and all of a sudden we're looking at potential claims.
Yeah, agreed. All right, so then we have the best practices, and we'll punch through these rather quickly as well, because I do see we have a couple of questions that we'd like to address before we conclude the program. In terms of best practices, I'll jump off here first, Carlos. I mean, I'll say that, and Carlos and I have this experience with our clients, is, it can be extremely straightforward and, dare I say, easy to comply with BIPA. Really the question is just getting that written policy together and getting the requisite written consent and notice from your employees. I mean, that is the real cornerstone of compliance here, and certainly something can be really straightforward to do. Carlos and I have worked on those sorts of disclosures and agreements with our clients on a pretty regular basis, and it can be very straightforward. Carlos, what are your thoughts in terms of best practices? I know there's a bunch of other ones here.
Right, and the thing that you always see is, how many of our clients have, policies, whatever the policy you're talking about, that is fairly late, it's fairly laid out, it's clear, it's all that information, but then it's, are you applying it? Are you, following through? You can have a policy, but if part of the requirement here is that we also have that informed consent, or the signature, the acknowledgement that I have been provided this information, that's critical. You have to have the acknowledgement by the employees that they are aware of the policy, that they are aware of the use of the policy, how long the information is going to be kept. Because, if you don't have that acknowledgement, it's fairly easy and simple for an individual to turn around and say, well, that was never provided to me. That was never, that information was never disclosed. And, I don't know of how many instances, one piece of paper might mean the difference between, having to move forward with litigation or kind of, taking care of it much sooner. So that, the critical part for me has always been get that acknowledgement in writing. And then of course training the supervisors who are the first line, the frontline people who are bringing on individuals on board, making sure that the information is presented to them, that they get that acknowledgement, and that you're addressing these things, that you're taking care of it, that it's not just in your policy, but you actually are following through and applying that policy in your workplace. So that's kind of the best practice that I always think. You have a policy, you got to apply it, and you got to do what's in it, what it says. Any other thoughts, Molly?
Yeah, no, I think that's right. Well, we're at the hour, but we do have a handful of questions that maybe we can tick through real quickly here. I know one question was raised about facial thermal scanners to check temperatures. I don't have is that covered by BIPA? Is that different than the sort of, the more traditional thermometers being used? It really honestly would depend on, my understanding generally of the technology used for facial thermal scanners is that it's not necessarily taking a facial image or geometry. It's really just taking sort of the heat points of a person's face. So, the answer to that question is, I guess it would depend. You'd have to dive in a little bit more deeply into the technology, the software that's being used. So it just would take a little bit more digging. I know there's also a question as to what states besides Illinois and California have BIPA statutes. There is Texas. Washington comes to mind. I know there was a move a year ago. I haven't looked into it further for Florida, similarly, to have a BIP, a biometric regulation. So it's gaining small momentum in the state level, but it's still, like I said, less than a dozen, and we are head and shoulders above in terms of its implementation other states. You know, the other couple of questions that I'm seeing here are really about sort of that lag period between learning about the law and either discontinuing the use of a biometric, you know, clock or otherwise. You know, are you safe if you sort of stop using it? Are you safe if you put in the policies compliant with Bipa as soon as you found out about it? You know, unfortunately, we can't say yes to that question because there's this long tail of a statute of limitations as we've covered. So, you know, it's, you know, unfortunate that we have to sort of say it's a bit of a hold your breath, cross your fingers sort of approach, at least from my perspective, but you know, it's certainly something where you could still run into hot water down the road. I mean, an approach that could be made is, do you approach employees that may have been, depending on the size of your company, do you approach people who may have been subject to the use of the biometric clock or otherwise, you know, about having not complied with the consent, disclosure, written authorization sort of requirements, requisites, to potentially, you know, quell that potential unrest now. It's really a discussion that needs to be had with counsel to sort of consider the downside of that or the upshot of it. Certainly, there's been companies we've seen where they've tried to what's called like pick off employees that they know may be subject to the law to put money in their pockets to avoid sort of a future large, you know, class action matter. So there's some strategies, but unfortunately, given the statute of limitations at issue and the look back period, you know, companies could still be subject to Bipa for practices that they employed, you know, 2 to 3 to more years ago. So,
Molly, do we have any other questions, or are we all set?
I think I covered them from what I'm seeing here. Certainly, you know, feel free, I would say, as you know, for reaching out to Carlos and or me in terms of, you know, individual questions, and we'll be sure to follow up with any developments beyond what we've covered today. So.
All right, and so we want to thank you for participating today. We hope that the information that we've provided has been helpful, brings some clarity to you. Obviously, it is the kind of thing that, you know, we will keep an eye on, and whatever developments we see, we will certainly continue to stay on top of those and blog on them, or, you know, even have another one of these events. So we want to thank you again for being a part of it today, and enjoy the rest of your day. Thank you.